Good morning. Welcome to this month's webinar on the Indian legal system in fraud prevention, monitoring and reporting. Over the last 3 months, we've been doing these webinars on a regular basis, and we've talked about code of conduct and ethics policy. We've talked about the whistleblower mechanism. This month, we're going to focus on the Indian legal system. So very briefly, we'll look at what checks and balances are in place legally as far as the private sector goes with respect to corruption and bribery, fraud, liability of fraudsters, what kind of whistleblower protection is afforded legally. And in recent times, in 2011, India had ratified the UNCAC. So as per this agreement, we are required to have a more robust legal system. So we'll also see how our Indian legal system fits in within the UNCAC's framework. Now, if we look at first corruption or bribery, as far as the public sector goes, there are various laws in place. For instance, the Indian Penal Code, Prevention of Corruption Act, all of these laws specifically address what needs to be done if there is a potential corruption or bribery in the system. So these laws take care of corruption and bribery matters as far as the public sector goes. Similarly, we have the Prevention of Money Laundering Act also, which acts as a check against money being transferred through various bank accounts, so on and so forth. Even as far as the investigating authorities go, we have the CVC at the top level. You have the CBI and the Anti-Corruption Bureau also, and these three agencies work together, to even act on specific whistleblower instances that come forward. So the entire mechanism as far as the public sector goes is at least well defined. Now, as far as the private sector goes, there is no specific law per se on bribery and corruption. The UNCAC has made some recommendations as to what kind of modifications need to be made in the Indian legal system, or rather, they talk about what exactly is bribery, what is corruption. These two terms are actually quite different from fraud, although in many, I think in common or in layman terms, that distinction is not really made. So as far as the Indian legal system goes, there is no specific law to curb or prevent bribery and corruption in the private sector. But since the ratification of the UNCAC, some amendments have been proposed to the Indian Penal Code, where a portion of the private sector is also going to be covered. Amendments have been suggested to the Prevention of Corruption Act as well, which we'll look at a little later as we move on. There's also a bill on the prevention of bribery of foreign public officials, which had lapsed, and a fresh bill is under progress. So as far as bribery and corruption goes, at the moment, there is no specific law, but it looks like over time, there will be some amendments made, and that system will probably be made more robust. Now, if we look at the laws on fraud, again, I think in one of the previous webinars, we looked at the terms fraud and corruption, and we said that they're very different. So as far as fraud goes, we still have, I think, a fair amount of laws, at least in the corporate sector, that act as a mitigation mechanism or put certain checks and balances to ensure that frauds are detected in a timely manner and reported. So for instance, we have Companies Act with the recent amendments on fraud reporting. We have SEBI, we have the listing agreement. So to start with, at the top, one of the basic requirements is the Code of Conduct and Ethics Policy. Now, although passively Clause 49 of the listing agreement requires a code to be in place, there is no law which says that this has to apply to all employees of the company. So in India, for the most part, I think the code of conduct and ethics is still adopted by practice rather than driven by law. And I think in the previous webinar, we'd also discussed what the basic requirements of the code of conduct and ethics are. um, the law as such does not dictate it. Over time, the private sector has built on this through best practices. It's also based on, I think, a level of awareness on what corruption is and what is a framework for ethical business that has driven the code. However, that said, most companies have a code, so even if the law does not very specifically dictate it, in practice, it's still being adopted by most organizations. Conflict of interest is another requirement within the UNCAC, and again here the Indian legal system sort of takes care of it. In the Companies Act, for instance, you have various sections that define what is a related party and what are certain contracts or agreements where a director can be defined to have a certain level of interest in. So in these cases, or in some cases, even the sanction of the company law board is required before a director engages in a contract, which could be of a potential conflicting in nature. In some cases, the directors voting in the board issues, if it's of a related matter, is also prohibited. So if a member of the board is at a meeting where they are discussing aspects on a contract where he has a specific interest, then in some cases the board members also precluded from voting on such contracts. Companies are also required to maintain a register of any related parties and any contracts with related parties. So as far as conflict of interest at the management level goes, I think our legal system fairly takes care of it. And as far as middle management and employees within the company goes, again, I think that's something that has developed with practice, and it's also included a lot more in the code of conduct and ethics policy. The next aspect is transparency. Now, how transparent are, or what is the legal requirement with respect to maintaining transparency as to who is really running the company? There's been an age-old debate of, the corporate veil. So, who is really managing the company? Who is owning the company? As far as this goes, our Indian legal system again has certain laws in place. So, under the Companies Act, every company is required to disclose the shareholding pattern. Even here, there has been some progress. I think until a few years ago, the shareholding pattern required a section called promoters. So with the recent amendment, the term promoters has been replaced with who is holding controlling interest. So rather than just looking at who owns the shares, the shift has gone to who is controlling most of the company's operations. And that's really what is driving the management of the company. So as far as the transparency aspects go, I think the legal system for private sector is fairly secure. And for listed companies, one has to disclose who the company secretary is, who the compliance officer is, and these are again mandated. Now, the catch here, though, is that India has about 800,000 to 900,000 registered companies, and less than 1% is listed in the stock exchanges. So, all of these laws and a lot of the more rigid procedures are applicable to listed companies and not so much to private companies. So that's one aspect that maybe the company law would be looking at in the subsequent changes. Now, as far as corporate governance practices goes, again, we have clause 49 of the listing agreement. And a few years ago, there were a lot of committees established, like the Naresh Chandra committee, that recommended what needs to be done to set these corporate governance frameworks in place. So as part of this, many companies, again, have adopted a code of conduct and ethics policy. There's a reporting at a director level and at an auditor level as to how the financial statements are being reported. and so on. So as far as the corporate governance practices go, India is still, I think, fairly in line with what the UN requires, and it's a fairly robust mechanism. Now, the next aspect is the maintenance of books of accounts, reporting, and disclosures. UNCAC defines what an offense is, and some of the offenses include establishment of, um, off the book or outside book accounting entries, or not recording an expenditure, recording expenses that have not been incurred. Now, as far as the Indian legal system goes, we have the Companies Act under the erstwhile Section 227 of the old Companies Act, which talks about the duties of the auditor. We have our Indian accounting standards and auditing standards. So there's a lot of onus that goes on the auditors and the directors of the company to ensure that the books of accounts are maintained well and that the financial statements are in line with the books of accounts. Over the years, the reporting disclosure requirements have also constantly undergone a lot of change, and India is slowly, I think, moving to a place in reporting where we're in line with the international standards. So as far as these aspects goes, with respect to maintenance of books of accounts, reporting, etc., we are still fairly, largely compliant with the UNCAC requirements. In 2003, we had the Serious Fraud Investigating Office also established that has since then started focusing on a lot of, uh, let's say, economic crimes or investigations in the private sector. And I think many of us must have read about cases that have been sent to SFIO for more detailed investigations. The Income Tax Act has also been playing a very crucial role with respect to the books of accounts and the reporting part. So, for instance, you have sections in the Income Tax Act which prohibit or which disallow claiming any expense that could be constituted as a bribe. The Income Tax Act also uh, sort of, it talks about, it also applies certain sanctions if there's a concealment of income. In case you're accounting for expenditure which is not real, then again there is a set of penalties for that. So the Income Tax Act again is fairly robust as to what kind of expenses can be allowed and disallowed, what kind of revenues can you actually claim as an income. In case there is a concealment, then what happens. So there are fairly, I think the Income Tax Act is again fairly robust, and India is largely compliant with the UNCAC requirements through a combination of the Income Tax Act and the corporate laws. Another aspect of anti-fraud again is mitigated through the competition law, which talks a lot about the good commercial practices. Even though it is not very express, there are certain implied areas which could be suggestive of corruption prone areas. For example, it talks about exclusive supplier contracts, it talks about bid rigging, collusive bidding. So any transactions where which could be driven through the contract side, the supplier side, or from a price side, which could be considered as a corrupt practices, are investigated by the competition law authorities. So as far as Competition Act also goes, I think India is fairly compliant with the UNCAC requirements in the sense that um, good commercial practices again are propagated through this particular law, and over the years they have been playing a more active role in investigating issues that have come up for reports. Now, while the legal system covers a huge part of these aspects, we still see that many of the private sector crimes are either not getting reported, or if they are reported, then the liabilities are not really to be seen, or it's not really there. So why is that so, right? So while we looked at what is the liabilities defined under the various laws, and this is what we found out. So as far as the Income Tax Act goes, there are definitely some penal provisions But this is more to do with allowing or disallowing an expense or applying certain sanctions if, let's say, there is a concealment of income. So it disallows expenses that constitute a bribe. In case you're falsifying books of accounts, then again, the IT authorities would step in for any penalties and prosecution. However, with respect to the liability of legal entities, and what I mean by this is if there is an economic crime committed by a company or the management of the company, then what really happens? So, what we found out is that as far as the legal framework goes, there's still a lot that needs to be done in this area, which could be the reason why we're hearing so many frauds coming out in the media, but we don't really see the legal entities being able to step in and take action against them. So, with respect to the legal entities, can any corporation be held criminally responsible? This has been an age-old debate for years. So, if you look at a company, it's not really a person, but it's a legal entity. Can you hold a company criminally responsible? Is a discussion that has been going on for years. But I think over time, the regulatory mechanism is now working towards how can we hold a legal entity responsible and what can be done. At the moment, though, there is no well-defined law that talks about this. Then the next step is if you cannot pin the responsibility of on the company, then what about the people who own and manage the company? So as far as liability of natural persons go, um, again it's not very clear in the sense legal person is not defined in the Companies Act or the Prevention of Corruption Act. Again, here, as far as the public sector goes, there is a lot. The framework is more robust, but as far as the private sector goes, there's still a lot of work that needs to be done as far as the legal system goes. So we still don't know there is still no proper definition of who a legal person is. So in which case, even if the company is held responsible, who exactly can it roll back onto? The public procurement bill, it is expected, will to some extent take care of this aspect because once this bill is passed, it is believed that it will apply, the liability will be extended at least to private bidders. So as far as public and private procurement transactions take place, to some extent this will be mitigated because the private bidder will also form part of the law and therefore that might to a certain extent that might act as a deterrent. The Companies Act does provide for certain offences or penalties that are applicable to a company or an officer of the company in case of any violation of the provisions of the Companies Act. However, it's still not entirely connected, and I think with a few more amendments in the law that might probably be taken care of. So as far as establishing the liability on legal persons or a legal entity goes, India is not fully compliant with the requirements of the UNCAC. The next aspect is the whistleblower protection. In one of the last webinars, we had talked about the whistleblower protection and what needs to be done. And I think what followed was that the private sector does not really have any well-defined laws. The recent Whistleblower Protection Act is also, it applies only to the public sector. So as far as the private sector goes, there's nothing really in the legal system that can protect the witness against retaliation. Most companies are taking care of this through the whistleblower policy itself. However, with no legal backing, it becomes a little difficult. And that's why in most companies, if you look at any statistics on anti-fraud or anti-corruption, the biggest source of identification of fraud comes in through a tip from a whistleblower. However, how many of us as employees in a particular company will be willing to raise the whistle is a question. And that mechanism can be strengthened only if the witness itself can be protected against retaliation through the legal system. So in case there is a conflict of interest also, so for example, if the employee is raising the whistle against his line manager or a colleague, there could be a conflict there. The legal system again needs to define a lot of these aspects. What about physical safety? What about identity? Should his identity be disclosed at the earlier stages itself? How can he ensure that he can take part in some of the proceedings? So for instance, if a private sector case has to be taken to court, then what then happens to the whistleblower? How do we protect his identity? I think a lot of these aspects are not covered by our law, and hopefully um, there will be something coming up in the future in these aspects as well. So as far as protection of witnesses, experts, and in general any person who raises the whistle against a potential violation goes, India is not compliant with the UNCAC requirements. So in order to have the entire legal system working, I think in a block or a chain mechanism, from what we're understanding, I think the earlier stages as far as defining what are the books of accounts, or building a framework for anti-fraud is fairly there. However, the latter half, for instance, protecting the witness, protecting the whistleblower, those are aspects that still need to be defined in the legal system. Even as far as the liabilities go, if all these are entirely there in a particular act or a law, then it would cover the entire cycle, and that might probably help in mitigating private sector corruption and fraud in a larger way. So we've been talking about the UNCAC, and just to give you a brief introduction, this is the United Nations Convention Against Corruption. This is a legal binding instrument. So any country that ratifies the UNCAC is bound by the convention. India ratified UNCAC in 2011, and it is a result of this ratification that many changes have actually come up in our legal system. So as far as the Whistleblower Protection Act for the public sector goes, the proposed amendments in the Indian Penal Code, all of these are actually to ensure that we're in line with UNCAC. So India is progressing towards a more supporting a more transparent business environment. And so what does the UNCAC talk about? As far as the private sector goes, there are certain requirements on anti-corruption and bribery. So it defines what is corruption, it defines what is bribery, and it says that there should be checks and balances to ensure that your business is transparent, whether it's giving a bribe or receiving a bribe. Um, the the legal system has to be fairly transparent and put checks and balances to identify these before it takes place. It also talks about fraud mitigation, maintenance of books of accounts, the accounting and reporting as far as accounting standards go, the auditing standards go, what needs to be disclosed to shareholders, how do you protect the witnesses, even in the case of court proceedings, what is it? It sort of provides a framework or a guideline as to what a good legislation must have to ensure that all of these aspects are well taken care of. So this is a publicly available document. You can visit the UNCAC site to see what the clauses are or what the requirements are. So to sum up, our Indian legal system, as far as the private sector goes, there still needs to be made a little bit more headway. Public sector has its own set of laws and rules and regulations. So as far as the private sector goes, we still need a law that talks about or prevents corruption and bribery. The liability or the pinning down of responsibility for economic crimes is still not very clear. So there has to be a proper prosecution mechanism of economic crimes. The reporting mechanism again isn't very clear. Most companies in the private sector conduct their own investigations, and once the issue is entirely known, it is very rare that they actually go to law enforcement authorities. So the reporting mechanism again needs to be clear. Who do we report to internally? What kind of frauds or what kind of corruption, bribery needs to be reported to the government or an external authority? That reporting mechanism is still not very clear in our system. Lastly, and the most important aspect is protection of whistleblowers, because people at the ground level are more aware of what is happening, and if there is a sense that they will be protected for blowing the whistle on any particular wrongdoing, then more number of cases will come to light, and that sort of works very well in creating an excellent anti-fraud mechanism. So hopefully we'll see more progress in the Indian legal system as far as the private sector goes, so that it is more in line with the UNCAC.